attorney today. This proceeding is being broadcast over the internet as a live stream. That means any member of the public can log on and watch this particular proceeding. Those who receive a cash or surety bond today will be reset to the state all-purpose calendar on October the 4th of 2022. Those who receive a signature bond will be reset for the notice. Again, I am Judge Melanie Williams, and today is September the 19th of 2022. Are there any announcements from the jail regarding medical resets?
Not from the South Annex, Your Honor, but as soon we finish with South Annex, courtroom 2 will be able to answer that question for you.
All right, perfect. Who do I have at South Annex?
Before you coming up is position number 12, Ms. Natasha Pumpilas.
All right. Good afternoon, Ms. Populous. Your case number is 22 CR 006316H, in which you're charged with unsafe vehicle equipment, driving under the influence of alcohol, less safe, and erratic or improper driving with the offense date of September the 18th. Do you understand your rights? You have a right to remain silent. You have a right to an attorney, and this proceeding is on the internet. Do you understand that?
Okay.
All right. Ms. Harvey, can I have the history, please?
Yes, Judge, this is the first arrest.
All right, thank you. All right, Ms. Duncan?
Yes, Your Honor, good afternoon. This incident occurred yesterday in the area of Old Holcomb Bridge Road. The defendant in this case, well, I just want to start with, there's a preset bond in this case of $1,200. It's $100 for the unsafe vehicle, $1,000 for the DUI less safe, and $100 for the improper or erratic lane change. Yesterday, officers encountered the defendant who was driving a motor vehicle to the point where the vehicle itself had a tire that was not in good working order. Specifically, the tire was not fully on the rim. It was off the rim, sort of bent. When officers encountered the defendant in this case, her eyes were red and watery. Her speech was slowed and slurred at the time, and they detected an odor of alcoholic beverage on her breath. Officers also noted that she was unsteady on her feet, had gait issues, and when she was standing still, she was swaying back and forth. They conducted field sobriety tests, and the evaluations did indicate that this defendant was likely impaired. And then this defendant was not able, she was stopped because she was not able to keep the vehicle entirely in the lane that she was in. The left tires had completely crossed over the double yellow line. Given the seriousness of this offense, Your Honor, this incident poses a significant danger to the community, given that she's likely driving under the influence, so much so to the point where she was driving on a car with not a proper working tire at that time and likely under the influence, Your Honor. Given that, the state is going to ask for a $4,000 surety bond, $3,000 for the DUI, and $500 for each of the other offenses. Given that, Your Honor, the state thinks that recommendation is more than reasonable given the facts and circumstances in this case. Nothing further from the state.
All right, thank you. Ms. Kim?
Yes, Your Honor. Miss Natasha Pumpilas, she is 35 years old. And after she got separated with her husband, she moved to Georgia for 2 jobs. She works at Fulton County, one of the schools, and also she works at night to clean houses to earn extra income because ever since she was separated, she does not have a child support. So she is the sole provider for 7-year-old son that she has. Right now, she is basically taken care of by her neighbor. And Your Honor, my client had a flat tire, which was very unfortunate and scary thing to happen at night. And she has 2 jobs. She works from 5 a.m. to really late night. She was very tired, but she was not drunken, Your Honor. And we would like to request for signature on bond. Since she's relatively new here, she want to get back to her job. She has to keep the job. And right now, there is no one who can actually co-sign for her bond. So we would like to request for signature on bond, Your Honor.
All right, thank you, Ms. Kim. At this time, the defendant will receive a $2,500 surety bond broken down as followed. $250 count one, $2,000 count two, and $250 for count three for the total of the $2,500. She is not to drive without a valid license issued by the Georgia DDS. She is to have no weapons, drugs, or alcohol as a condition. Is there anything further from either the state or the defense?
Nothing further from the state.
Nothing further, Your Honor.
All right, best of luck to you, ma'am. Who do we have next?
Next, we have position 13, Ms. Allison Rivera.
All right, good afternoon, Ms. Rivera. Your case number is 22 CR 006313D, in which you're charged with battery with the offense date of September the 18th. Do you understand your rights?
Yes, ma'am.
All right, thank you. Ms. Harvey?
This is the first arrest, Judge. Nothing
All
further.
right, thank you. All right, Ms. Duncan?
Yes, Your Honor, this incident, there is not a preset bond on this case. This incident did occur yesterday at the area of 4689 Roswell Road. In this case, Your Honor, the victim's name is Julian Velasquez. Julian, if I'm spelling last name, Velaquez. In this case, Your Honor, the defendant admitted to officers that she punched the victim in the face. She stated to officers that it was because he was smoking and either herself or someone near them was pregnant. The state has a concern in this case that this defendant may be a danger to the community, given that from what we know, this seems to be a random act of violence on a stranger, Your Honor. After being punched in the face, the victim received a bloody nose and a cut. So there's a laceration and a bloody nose that resulted from the force behind the punch that the defendant gave to the victim in this case. Given that, Your Honor, we understand that it's her first offense. However, given the seriousness of the offenses alleged and the violence and injuries that occurred, we think that a $3,000 surety bond is more than reasonable in this case. No further contact with the victim in this case, or stay away from that location. Previously stated, 1 day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
All right, thank you, Ms. Kim. Well,
Yes.
before I go to you, Ms. Kim, let me sound for Mr. Velasquez. Is there a Mr. Velasquez on this Zoom conference who wishes to be heard? All right, hearing none, please proceed, Ms. Kim.
Yes. Miss Allison Rivera, she is 17 years old, Your Honor, and she is currently high school student, 11th grade. And Mr. Julian Velasquez is not a stranger. Indeed, he is stepfather. My client resides at his place during the weekends to stay with her mom. And Mr. Julian has tried to evict her mom and her lately without any writ of possession nor court action. He just tried to kick them out, and there was those issues that was going on. And of course, smoking in front of the pregnant lady is very bad. And we would like to request for signature on bond. Her father, Jose Rivera, can co-sign her to get out of the jail. She is GPA 3.5, great student. She want to be a nurse, and we would like to have for her to have another chance. Thank you, Your Honor.
Question, what is this 4689 Roswell Road? Is that a business or is that
No,
alleged to be a
it's a-
home?
Apartment where Julian Velasquez and my client's mother and stepfather are residing there, and my client is actually visiting there during the weekends so she can spend time with her mom. So that's
Okay.
a residential area.
Okay. All right. Is there anything further from either the state of defense?
Nothing
Nothing further
further.
from the state.
All right. At this time, the defendant is going to receive a $6,000 signature bond through pretrial services. She's to take the one-day anger awareness course and have no further contact with the alleged victim. She must also stay away from that address. She is to have no alcohol, drugs, or weapons as a condition.
May she have
Anything?
one-time law enforcement officer visit so she can
Yeah,
have
she
her
can.
personal belongings?
Any items she may have there, she can retrieve with a one-time law enforcement escort.
Thank
All
you.
right. Best of luck to you, Ms. Rivera. Who do we have next?
Thank you. That's it from the South Annex, Your Honor. Thank you.
All right, take care. Have a great afternoon.
You too.
Your Honor, may she also waive the utility bill so her father can come and take her out?
That's fine. Yes, if you'll send me the waiver, Ms. Harvey, I'll sign it. Or please
Thank
send to
you.
Ms. Bridgewater to include with the rest of the orders.
Thank you, Your Honor.
All right, who do we have next?
Good afternoon, Your Honor. Next, we have position number 3, Mr. Bray, Jesse Bray.
All right. As courtroom 2 heard their rights?
Yeah. Oh, yes, they have.
And any other announcements regarding medical resets at courtroom 2?
We have a medical reset on position 7 and a medical reset on position 1.
All right, thank you so much. I appreciate you letting me know.
And also position 14, we put a waiver in for appearance.
Is that now position 13? I think that there's 2 calendars. Is that Divine Smith?
Yes,
Yeah.
Okay.
Yes, Your Honor.
Okay.
And good afternoon, Your Honor. If I may, I believe the medical reset is for position 6, Jackson.
Okay, not 7 because it moved
Also,
down.
it's a whole
Okay.
different, I guess it's a different calendar. I got the other one.
So 1 is still going to be reset. 'Cause I'm sure 1 is still the same.
Yes, that is
And
correct.
position 6 is now the reset, not 7. All right, thank you for clarifying that point. Good afternoon, Mr. Bray. Whoever's speaking, please mute. I'm sorry, Katrina, what are you saying? I'm
I
sorry.
was just letting everybody know that a revised counter went out, so there should be only 13 people on the position on the counter. So if you have 14, 1 was duplicate, so that's just letting you know, so the numbers on the calendars may not reflect to where they are, so they need to say the names.
Okay, thank you.
All right, good afternoon. Mr. Bray, your case number is 22 CR 006318C, in which you're charged with criminal trespass with the offense date of September the 18th. Do you understand your rights?
Yes, I do, Your Honor.
Thank you, Ms. Harvey. Can I have the history, please? Thank you.
Yes, Judge. 11 cycles, 2 probation violations in the past 10 years. Misdemeanor convictions include a 2010 willful obstruction of a law enforcement officer in possession of marijuana less than an ounce, a 2014 conviction for willful obstruction of a law enforcement officer. The last arrest was August 30th of this year for disorderly conduct and criminal trespassing out of Fulton County. No disposition listed, Your Honor. And in addition, the defendant appears to be on probation for armed robbery. That's out of Fulton County. Sentenced July 10th, 2014 to 9 years probation. Nothing further, Your Honor.
Thank you, Ms. Harvey. Mr. Dudley, please
Yes, Your Honor.
proceed.
Thank you, Your Honor. This incident took place on September 18th of 2022 at the Waffle House on 135 Andrew Young International Boulevard. The defendant was at the Waffle House and he started banging on the front window pane and started screaming profanities at the customers inside of the Waffle House and outside of the Waffle House. The defendant continued to act in a violent manner towards other people at the restaurant, at which point he was asked to leave several times and he refused to do so. As such, he was charged with criminal trespass. As pretrial mentioned, the defendant has a criminal history involving arrest for criminal trespass back to 2010 and twice this year in the year of 2022. He has probation violations within the last 10 years and is currently on probation. Given the defendant's criminal history, the state has a concern of a risk of reoffending. There has been a previously set bond of $500 for surety bond on this case. The state is going to recommend a $1,000 surety bond, a stay away from the incident location, and no drugs, alcohols, or weapons while out on bond. Nothing further from the state.
Thank you, Mr. Dudley. Ms. Gant?
Thank you, Your Honor. Mr. Jesse Bray is 30 years old. He has been in the Atlanta, Georgia area his entire life. Your Honor, he completed high school and he tells me that when he is able to work, he works at Sweet Lounge. He strongly denies the allegations. In fact, he states that he did not know why police arrested him. He states he asked to speak to an attorney. He asked to have his charges stated. He states that the police know him and basically try to harass and arrest him every time that they see him. I do acknowledge my client's history. However, he is in no position to pay anything toward bond. Therefore, I'm requesting a signature bond, Your Honor. We are unopposed to the stay away. And if Your Honor determines that he is ineligible for a signature bond, then I would ask that bond be no more than $100. Thank you.
All right, thank you. At this time, Mr. Bray's bond will remain as set at the 500 surety. He must stay away from the location on Andrew Young and have no alcohol, drugs, or weapons. Is there anything further from either party?
Nothing from the defense. Thank you, Your Honor.
All right, best of luck to you, Mr. Bray. Who do we have next?
Next, Your Honor, you have position number 5, Mr. Cofer, Angelo Cofer.
That's position 4. All right, good afternoon, Mr. Cofer. Your case number is 22 CR 006308C, in which you're charged with simple battery family violence with the offense date of January 3rd of 2022. Do you understand your rights? I'm sorry, he's muted. Does he understand his rights?
Yes, ma'am, Your Honor.
Thank you. All right, Ms. Harvey.
10 cycles, Your Honor. A 2007 theft and larceny misdemeanor conviction, 2009 simple battery, 2015 conviction for abandonment of dependent child. The last arrest was July 8, 2019 for abandonment of a dependent child out of Clayton County. There was a conviction as well, Your Honor, and nothing further to add.
Is he recommended? I thought I saw that on the list.
Yes, Your Honor.
All right, thank you. Mr. Dudley?
Yes, Your Honor. Make sure. Am I on mute? No.
No, we can hear you.
All right, yes, Your Honor. This incident took place on January 3rd of 2022 at 1059 Oglethorpe Avenue Southwest. The defendant was in a physical altercation with the victim, Shadia, S-H-A-D-A-I-E, Dennis. The defendant hit Miss Dennis in the face repeatedly with his fist and pulled her to the ground by her hair. The defendant also prevented Miss Dennis from leaving the home during his attack. Miss Dennis informed officers that this was not the first time that she was attacked by the defendant. However, this was the first time that she had called the police. She told the police at the time that she had moved out, and the state has not confirmed this with the victim. As our victim advocate reached out, we were unable to get in touch with the victim. But the victim's statements to the officer gives the state's concern about the defendant's risk of reoffending. The state also has concerns about the defendant influencing the witness as they live together, and we were unable to confirm that they currently don't. The state is going to recommend a $3,000 surety bond, no further contact with the victim, a stay away until confirmed by a police escort that Ms. Dennis is no longer staying at the location, and no alcohol, drugs, or weapons while out on bond. Nothing further from the state.
All right, thank you. Before I go to Ms. Gant, I'm going to sound for Ms. Dennis. Ms. Dennis, if you are on the Zoom call and wish to be heard, this is your opportunity to do so. I'm sounding for Ms. Dennis. All right, hearing none, Ms. Gant.
Thank you, Your Honor. Mr. Angelo Cofer is 34 years old. He has been in the Atlanta, Georgia area. His entire life, he has 4 children, none of which he shares with the complaining witness. His children are ages 17, 13, 12, and 8. Your Honor, we are opposed to the stay away order. Mr. Kofer informs me that that is his residence, and this incident occurred back in January. He states that he has not seen the complaining witness since then. Mr. Kofer completed high school. He is currently employed at White Aluminum Fabrication. He has been in that position for 1 year. He strongly denies the allegations. He states that she bit him and that he was basically trying to get his teeth out of her arms. And Your Honor, the warrant clearly states that there was a witness there who did not witness Mr. Kofer assaulting Ms. Dennis. There was an anonymous male who stated that it was Ms. Dennis who in fact hit my client. And lastly, the warrant also states that the police were not able to even get a coherent statement out of her until after the fact because the complaining witness was intoxicated. Therefore, Your Honor, I am requesting a signature bond. I know this is not about guilt or innocence. However, my client does not have any recent convictions for violence. This simple battery is 2009. It's far remote. He is recommended for a signature bond. The state's contentions regarding reoffending and or influencing the witness are unfounded because again, this incident is alleged to have occurred back in January. He hasn't seen her, nor does he want any contact, Your Honor. Thank you.
All right, thank you. At this time, the defendant's going to receive a $5,500 signature bond through pretrial services. Defendant is to have no contact whatsoever with the alleged victim, last name Dennis. He must stay away from Oglethorpe Avenue if the victim resides there. He can return one time with a member of law enforcement to ascertain whether or not the alleged victim is at that location. If she is not there, he may return to that residence. He is to complete the one-day anger awareness course, and he is to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing further from the defense. Thank you, Your Honor.
Nothing
All right.
further for the state.
I see you raising your hand, Mr. Cofer. The best thing to do is speak to your attorney.
And I will give you
Okay.
a call, sir. I will give you a call very shortly.
Okay, thank you. Thank you over there.
All right. Take
Next,
care.
we
Have a good day.
Position number 7, I believe I fixed this. Should be Mr. Kakul, am I correct?
I have Joel Kakule. Is that how you pronounce that?
Yeah, I think so, I'm not sure. Yeah.
All right. That's who I have for position 7.
That's what I got.
Thank you. Yes. So your case number is 22 CR 006310C, in which you're charged with 1 count of battery family violence with the offense date of September the 18th. Do you understand your rights?
Yes, ma'am.
All right. Thank you. Ms. Harvey?
3 cycles, Your Honor. All arrests are out of Cobb County and appear to be open. There's a February 2022 theft by receiving stolen property felony, March 28, 2022 criminal damage to property in the 2nd degree felony. And the last arrest was May 30th of this year for simple battery, all out of Cobb County, no dispositions listed. Nothing further.
All right. Thank you, Ms. Harvey. Ms. Duncan?
Yes, Your Honor, this incident did occur yesterday at 751 Fairburn Road in Atlanta. In this case, the victim is Unique Boria Sanel. First name is spelled AUMUNIQUE. Last name is BORIA -SNELL. In this case, Your Honor, the state would just like to make the court aware that 2 of those open cases out of Cobb County appear to us to involve the victim in this case, the simple battery, which the defendant in this case received a $2,000 surety bond and conditions of no further contact in any way, shape, or form. In this case, the defendant punched Ms. Snell in her face, leaving her left eye swollen. They do share a child and they do live together. Upon speaking to Ms. Snell this morning, she indicated to our victim advocate that they're in a relationship and they live together. However, she has concerns in this case, Your Honor. She stated to our victim advocate that the defendant has been blackmailing her and manipulating her about getting in trouble for having contact, even though she knows she's not supposed to, and using that against her as a means to not call the police during these attacks. In addition, he stated to us, and it's in the police report, that he uses the child to control her. When they get into arguments, Your Honor, he will take the child and leave. She does not wish to speak. She may be on, but however, she does not wish to speak, and all her comments were made to the victim advocate today. She did also state that during this altercation, he was holding their 6-month-old child and threw the child to the ground to attack her. She doesn't want to have any contact with this defendant. She wants him to stay away from her location. She does not feel that at this time it would be appropriate for him to have contact with the child because of the alleged incidents that occurred during this attack. Like I stated, both of his two of the open cases out of Cobb County do involve this victim, in one of which he was throwing her stuff out and he grabbed her by the neck. She's not comfortable with third-party transfer because he does use the child to control and manipulate her. She said that she is filing for a TPO. She wants, she's okay with a one-time law enforcement contact. Given the facts and circumstances, Your Honor, we have a concern about the risk of reoffense here because as stated by the victim and as noted in his criminal history, there are several instances, and upon further investigation, they involve this particular victim. We have a concern about intimidation here as well. As previously stated, the child and their status is constantly used against her to try to persuade her not to call the police when he does these things. We have a fear of the danger for this particular victim, given that this is not the first offense against her, and his likelihood to respond to the legal process, given that he was told not to have any further contact with her, and it was his responsibility to uphold that. It was his responsibility to uphold that, and he has not done that. And as I stated previously, he's threatened that she would get in trouble because of the stay away on the bond if she called the police on him for doing this. However, our victim is concerned for her safety, so she chose to call the police today. Given those facts and circumstances, the state is going to be requesting a $4,000 cash bond. No further contact with the victim in this case, and no further contact with the child in this case, unless there is a legitimization that is properly filed and executed, a stay away from the incident location, one-time escort, 2-week anger management, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state, Your Honor.
Thank you, Ms. Duncan. I'm going to sound for Ms. Berea Snell and just confirm that she does not wish to speak. If you don't wish to speak, you can leave your camera off.
Hi, I'm okay speaking.
All right, you'll need to turn on your camera.
And thank you, Your Honor. I do apologize for interrupting. May I I would request that Ms. Boreas Snell limit her comments to regarding whether or not she wants to have contact, and I think that the state has made that clear.
And the state would object because any of her testimony is relevant to the IALA factors.
All right, we'll allow Ms. Snell to speak in a limited capacity. Ms. Berea Snell, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
I will hear limited testimony from you today. However, what the court is most concerned with is whether you wish to have contact with the defendant. And you can put your hand down. What would you like to tell the court at this time?
More than anything, I'm concerned about the safety of my son. I've been trying to end the relationship on several occasions, but because he lives with me, I would have to go through an entire eviction process. I want a protection order, and I want to be able to move from this location so he can no longer find where I am located and manipulate or influence me to get back in the relationship. I will say in honesty, I did hit him first in this particular instance, and that was because he was keeping my son from me. But it was more pushing and scratching, reaching for my son. And then at the point that he put my son down, he just continued to sock me in the face and my body, and all I could do was, cover my head. But that's all I would like to share at this time.
Thank you. Excuse me. I do appreciate you making those statements. Thank you for being here today. All right. Ms. Gant, please proceed.
Thank you, Your Honor. Mr. Joel Kukuli is 24 years old. He has been in the Atlanta area for about 6 months. He relocated here from Denver, Colorado. He shares a 6-month-old with the complaining witness, Ms. Boria Snell. Your Honor, we are unopposed to the stay away at the incident location until unless and until Ms. Boria Snell relocates. He informs me that is his residence. Both their names are on the lease. He doesn't have an alternate residence, Your Honor. He doesn't have any family here. Mr. Kukuli completed high school. He also has an associate's degree in arts. He is currently employed at Cardinal Health. He has been in that position for the past 4 months, and he offers a competing version, Your Honor. He states that they were at a party and were on a date, and that when they returned home, he was trying to feed the baby, and Ms. Boria Snell, was trying to actually get the baby from him to feed him. My client continued to feed the baby, and then he stated that she began yelling at him, throwing objects. She hit him with the stick. She kept at him. He states that he recorded all of this and that it was he, in fact, who called the police. He states that he was scratched on his arm, his back, his right arm, and his wrist, and that she ran away. And then, of course, when she came back to the scene, she made it up that he actually attacked her. Now, I do acknowledge my client's history, these open cases, Your Honor. However, he is presumed innocent. We did not hear about any convictions whatsoever. We heard the witness herself state that she attacked my client initially. So I am asking the court for a signature bond, Your Honor. And if Your Honor determines that he is ineligible, I would ask for a surety bond. And we are willing to go with the $4,000 surety bond, Your Honor. We are opposed to the 2-week anger awareness course. We believe that that is not founded at this time. And again, we are unopposed to the no contact and the stay away orders with the one-time law enforcement escort. And again, we would lastly request third-party transfer. Thank you, Your Honor.
And they would just like to add that given
Very briefly, Ms. Duncan, I think I've got a clear picture here. Go ahead.
Yes, I was just gonna say that the warrant says that there was, the police noticed swelling to her face that would indicate she was struck at some point during the altercation. Nothing further going from the state.
All right, thank you. At this time, defendant's going to receive an $8,000 surety bond. He is to have no further contact with the alleged victim, last name Boria Snell, and he must stay away from the address on Fairburn Road. He can return one time with a member of law enforcement to get any items. He can engage a third party to arrange transport of the child, and he is to have no weapons, drugs, or alcohol as a condition. Is there anything further from either the state or the defense at this time?
Nothing from the defense. Thank you, Your Honor.
Anything, Ms. Duncan?
Nothing from the state.
All right, Becky.
And Your Honor, this concludes my business. May I be excused?
You can, Ms. Gant. You don't wish to stay for the entire calendar with us?
Not today,
Usually you're
Your
with
Honor.
us the whole time. All right, Ms. Gant, we will see you. Take care. Have a good afternoon.
Thank you. Bye-bye.
All right, bye-bye. Who do we have next?
We have position number 2, Mr. Gregory Barnes.
All right, Mr. Barnes, your case number is 22 CR 0063007A, in which you're charged with battery family violence with the offense date of September the 18th. Do you understand your rights?
Yes, ma'am.
Thank you, Ms. Harvey.
One moment, Your Honor.
All right.
This is the one cycle out of Georgia, 2 cycles out of the state of Virginia, and 5 arrests out of Maryland. There is a 2018 larceny conviction out of Virginia. The last arrest was made for April 17th, 2022 for simple battery out of Fulton County. That's under case number 22 CR 002291E. That's an open case. And there is also an assault in 2019 out of Maryland. No disposition listed. And nothing further, Your Honor.
All right, thank you. Mr. Dudley?
Yes, Your Honor. This incident took place on September 18th of 2022 at 1991 Delow Drive Southwest. The defendant started a physical fight with his girlfriend, the victim, Dream Jackson, who lives with the defendant. And during the altercation, the defendant kicked Ms. Jackson in the face, and he hit her in the face with a cleaning liquid bottle. The two have lived together for 2 years, and they were in a romantic relationship at the time of the incident. As pretrial mentioned, the defendant has an open case of simple battery family violence involving Ms. Jackson, and he was released on a $5,000 signature bond with the condition to have no further violent contact with the victim. That was on April 18th, 2022. Just 5 months later, here he is again in violation of his bond conditions by having violent contact with Ms. Jackson. That gives the state serious concerns of his risk of reoffense. And given the relationship that existed between the two at the time of the incident, the state also has concerns of the defendant influencing the witness. I believe the recommended bond on this was to hold without bond, and the state is going to recommend a $2,000 cash bond, given the nature of the offense and the history that exists between this defendant and his attacks on the victim. No further contact with the victim, and a stay away from the incident location, along with no alcohol, drugs, or weapons while out on bond. Nothing further from the state.
Great, thank you. I'm going to sound for Ms. Jackson. Is Ms. Jackson present on the Zoom conference and wishes to be heard? All right, hearing none, we will go. Is it Ms. Kim's case?
No, Your Honor, this is conflict case.
Oh, is Ms. McLeod back?
Yes, I hope so.
Oh, we may have to come back to this. I wish I had checked for that.
Okay, she didn't get back?
No, I don't believe Ms. McLeod is back.
No, she's not back. She said, can she do her cases at the end of the calendar because she's with Judge Tilden right now.
All right, I'll push her to the end of the calendar. We can go to position number 8, Mr. Mario Lewis.
Let's try to keep all of that in our minds as best we can. All right, Mr. Lewis, your case number is 22 CR 006314B, in which you're charged with 1 count of theft by taking, 1 count of loitering and prowling, 1 count of willful obstruction, and 1 count of possession and use of a drug-related object, each with the offense date of September the 18th. Do you understand your rights?
Yes, ma'am.
All right, Ms. Harvey.
29 cycles, Your Honor. At least 2 probation violations in the past 10 years, also 1 parole violation, 2003 battery and criminal trespassing conviction, a 2009 conviction for criminal trespass. Also has felony convictions from 2007 entering auto, 2009 entering auto, and a 2010 burglary. He was sentenced October 27th. I think that's, let me double check one moment, Judge, but it appears to be an active probation case, but let me double check. Okay, yes, October 27, 2010. I wrote the year down wrong. 10-year probation, 10-year confinement, and 10-year probation was the sentence, and nothing further.
All right, thank you so much, Ms. Duncan.
Yes, Your Honor, in this case, there is an $8,000 preset surety bond. In this case, it's $2,500 on the theft by taking, $1,500 on the willful obstruction of a law enforcement officer, $2,000 on the loiter prowl, and $2,000 on the possession of the drug-related objects. In addition to what pretrial has stated, this defendant also has several related arrests in its history. In this case, it did occur yesterday as well at the Juno Construction Company site located near 6th and Peachtree Street in Atlanta. In this case, Your Honor, the defendant was captured on surveillance entering the construction site and putting on a vest as if he worked at that construction site, going on the site, grabbed tools from that location, and then proceeded to leave the premises with those tools. But before he could leave the premises with those tools, he was encountered by several officers. Upon being encountered by those officers, he hopped on a bicycle and began to pedal away from the officers at a high rate of speed against the officers' commands to stop and remain on the scene. However, In the defendant's attempts to flee from said officers, he slammed into the back of a marked patrol car, leaving damage to the patrol car. And at that time he was apprehended, and upon apprehension, officers did locate a glass pipe with residue on both ends of that pipe. Your Honor, given this defendant's history, we do have a concern about the risk of reoffense. He does have that open probation for burglary, as well as other death-related arrests and offenses in his history. We do have some concern about flight risk. There are a couple remote FTA arrests. And we have a concern about his likelihood of response to the legal process. It's implied by Georgia law that you not commit any more crimes while you're out on probation, parole. However, this defendant has continued to violate Georgia law. So in this case, Your Honor, we're going to be asking that also, the only reason the state is not charging this as a burglary at this time is because we can't verify the completeness of the structure that was entered into at that time. However, given the facts and circumstances, as well as the defendant's present IALA factors, we think that $8,000 surety bond that is preset is more than reasonable in this case. We're going to ask that this defendant stay away from that incident location, that there be no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
All right, thank you, Ms. Kim.
Yes, Mr. Maria Lewis is 41 years old, Your Honor, and tomorrow is his birthday. And this incident, Your Honor, has happened yesterday, and he has been here in Georgia for 41 years, all his life. He has 7 children and 3 grandchildren here in Georgia. He's got strong ties to the communities. He's not a flight risk. He also started his new job at kitchen cleanup at night from last Friday. He really want to keep that job so he can be more productive. Also, he completed GED. Your Honor, we would like to request for a signature on bond, and yet, if Your Honor is not inclined to give him a signature on bond because of his histories, we would like to request that the bond will be set maximum $2,000. Thank you.
All right. At this time, the defendant will receive a $4,000 surety bond, $1,000 for each charge. He is to stay away from the incident location and have no alcohol, drugs, or weapons as a condition. Is there anything further from either party?
Nothing further, Your Honor.
Nothing further.
All right, best of luck to you, sir. Who do we have next?
We have position number 9, Mr. Marapelli.
All right, good afternoon. Your case number is 22 CR 006315C, in which you're charged with 1 count of driving under the influence of alcohol, 1 count of driving and failure to use your turn signal, I believe, and 1 count of DUI less safe, each with the offense date of September the 17th. Do you understand your rights?
Yes.
Was that a yes?
Yes. Yeah.
All right, thank you. Ms. Harvey?
Yes, Judge. 1 arrest from March 10th, 2020 out of Pennsylvania for DUI. No disposition listed. Nothing further.
All right. Ms. Duncan?
Yes, Your Honor. This incident did occur on the 17th of September in the area of Kimball Bridge Road. In this case, Your Honor, officers observed the defendant in this case drive in the turn lane and exit the turn lane inappropriately several times. That exit particularly had a concrete divider. They also witnessed the defendant drive over the concrete divider that was meant to stop drivers from making that type of maneuver. At that time, officers initiated a traffic stop. And while speaking to the driver of the vehicle, which was the defendant in this case, they noticed that his eyes were bloodshot and watery. They noticed an odor of alcoholic beverage coming from his person. The defendant in this case did agree to field sobriety examinations, and that field sobriety did show clues of impairment. The defendant was arrested and read implied consent and agreed to take the intoxilizer. And the test results showed at that time a blood alcohol content of 0.1. Your Honor, given this defendant's history with DUI arrest out of Pennsylvania. The state does have a concern about the risk of reoffense. As the court well knows, DUIs are very dangerous, and he could have hurt himself and others on the road with that type of behavior. The state is going to be requesting a $6,500 total surety bond. That's $3,000 per DUI and $500 for the failure to signal. We're requesting a surety for those. No alcohol, drugs, and weapons, no further violations of Georgia law, and no driving. Nothing further from the state.
All right, thank you, Ms. Kim.
Yes, Your Honor. Mr. Meripelli, he is 44 years old, Your Honor. He has been here in Georgia for 7 years, and he has 2 children who are minor, and he is currently married, and he has been IT technician professional for the last 20 years. And he also has a bachelor's degree at electrical engineering, Your Honor. We would like to request for a signature on bond, and yet, if Your Honor is not inclined to give him a signature on bond, we would like to request for maximum $2,000 surety bond. Thank you.
All right, at this time, defendant will receive a surety bond in the amount of $4,250. It'll be $2,000 per DUI and $250 for the signal change violation. He is to have no alcohol, drugs, or weapons, and he is not to drive without a valid license issued by the Georgia DDS. Is there anything further from either party?
Nothing further, Your Honor.
Nothing further.
All right, best of luck to you, sir. Who do we have next?
Next, we have position number 10, Mr.
All
Thomas.
right. All right, good afternoon. Your case number is 22 CR 006309A, in which you're charged with battery. Do you understand your rights?
I do.
All right, thank you. Ms. Harvey?
What was that last name, Judge?
It's position 10, Thomas Peach.
Okay.
Or Page.
I have it.
I'm sorry, pronounce it for us.
Peach.
Peach. Okay, Mr. Peach.
2 cycles out of Georgia, 1 arrest from the state of California, and 3 cycles out of Ohio. There's a 2017 battery out of California with no disposition, a 2014 DUI. The last arrest was April 27th, 2022 for DUI out of Ohio. No disposition was listed, Your Honor, and nothing further.
All right, thank you. Ms. Duncan?
Yes, Your Honor. In this incident, the defendant punched the victim, Mondrell Smith, Mondell Smith, in the face, causing him to sustain a black eye. In this case, the state does have a concern about the risk of reoffense, given that this defendant does have a battery arrest from 2017 out of California. We also have concerns about intimidation of the witness. Our victim advocate was able to make contact with the victim in this case, and he stated that they are roommates and that this was not the first time that the defendant has been physically violent towards him, but this is the first time that he's called the police. He stated to our victim advocate that he does not want contact and wants the defendant to stay away from the residence. He also stated to our victim advocate that the landlord was also on the phone, and the landlord stated that she does not want the defendant to return to the residence due to him being a constant problem. The defendant did, my apologies, the victim did seek medical attention for his eye and was just leaving the hospital when we were able to make contact with him. Given that, we're going to request a $3,000 surety, no further contact with the victim, a stay away from the incident location, 1-day anger awareness, no alcohol, drugs, or weapons, and no further violations of Georgia law. You give me 1 second, I'll give you the stay away address, which is 2624 Peyton Road, Peyton Road in Atlanta. Nothing further from the state.
Thank you. Ms. Kim?
Yes, Your Honor. Mr. Thomas Pitch is 37 years old, and he has been here in Georgia about 4 months. He moved from Ohio to Georgia for his film project that is going on here in Georgia. He's an independent contractor, and his film project, he gets more business here in Georgia. So he plans to stay here longer. He has no children and he does not have any family members here in Georgia yet. He graduated from high school, and also he is currently in medical discharge from the Army. So he's actually in the Army as well. And that's it, Your Honor. We would like to request for signature on bond, and yet if Your Honor is not inclined to give him a signature on bond, we would like to request for maximum $1,000 surety bond. He has nobody to sign him out right now, so any bond will be, other than signature on bond, will be a no bond for him right now. Thanks.
All right, at this time, Mr. Peach will receive a $2,500 surety bond. He is to have no, oh, I'm gonna sound for Mr. Smith. I apologize. If Mr. Smith is present on the Zoom conference and wishes to be heard. All right, hearing none, $2,500 surety bond. He must have no further contact with Mr. Smith and must stay away from the address on Peyton Road. He can return one time with a member of law enforcement to get any items that might be in that location. He is to have no alcohol, drugs, or weapons. Is there anything further?
Nothing further, Your Honor. Thank you.
Nothing further.
All right, best of luck to you, Mr. Peach. Who do we have next?
Your Honor, can we go back to position number 2? I believe Ms. McLeod.
Yeah, Ms. McLeod is here, that's fine. We kind of have to do the whole thing again. Ms. Harvey, can we please have the history?
Yes, Judge, that was 1 cycle in Georgia, 2 cycles out of the state of Virginia, and 5 cycles out of Maryland. 2 FTAs in the past 10 years. The last arrest was April 17th, 2022 for simple battery out of Fulton County. That was an open case under 22 CR 002291E, a 2018 larceny conviction out of Virginia. And there's also an assault in the second degree arrest in 2019 out of Maryland with no disposition, and nothing further.
All right, thank you, Mr. Dudley.
Yes, Your Honor. The incident took place on September 18th of 2022 at 1991 Delow Drive Southwest. At that incident, the defendant started a physical fight with his girlfriend, Dream Jackson, who lives with the defendant. And during the altercation, the defendant kicked Ms. Jackson in the face, and he also hit her in the face with a cleaning liquid bottle. The two have lived together for 2 years and were in a relationship at the time of the incident. And pretrial noted there is an open simple battery family violence case involving the same victim, Ms. Jackson. The defendant was released on a $5,000 signature bond with the condition to have no further violent contact with the victim on April 18th of 2022. And 5 months later, he violated the bond conditions by having violent contact with Ms. Jackson in this case. The state has concerns of his risk of reoffending due to that. Given the relationship that existed between the two at the time of the incident, the state also has concerns that the defendant could influence the witness. And also, given the 2 FTAs on his criminal record within the last 10 years, gives the state a concern that he's a potential flight risk. Given that reasoning, the state is going to recommend a $2,000 cash bond, no further contact with the victim, a stay away from the incident location, and no alcohol, drugs, or weapons while out on bond. The state would like to also mention that this was a dual arrest and that Ms. Jackson was arrested and charged with aggravated assault on the felony count.
All right, thank you. Ms. McLeod?
Yes, Your Honor. My client is 30 years old. He has been living in Atlanta for just over 2 years. He and the alleged victim moved to Atlanta from the state of Maryland because she wanted to live in Atlanta. My client wanted to support her. My client is the father of a 5-year-old daughter. He is gainfully employed, or was at the time. He tells me, Your Honor, that in this case, the alleged victim was the aggressor. She attacked him. He has several stab wounds on his body and had to be taken to Grady Memorial Hospital. He was shocked that he was arrested, Your Honor, because his mom called the police because she saw that he was being attacked. He asked his mom to call the police, and his mother called the police. He did not expect to be arrested because the alleged victim attacked him and he was merely trying to defend himself. The fact that the alleged victim was arrested and charged with aggravated assault supports my client's position that she was the aggressor and that she attacked him. My client tells me that he has somewhere else to go. He does not wish to have any further contact with her. He does need a one-time escort to go back to the location to get his belongings because he does have significant belongings there, but he doesn't wish to live there anymore, and he does not wish to have any further contact with her. Your Honor, even though there is something outstanding against him, in this case, I believe that the facts support that he was not the aggressor. Therefore, I would ask the court to give him a signature bond. He tells me that he was recently very ill and hospitalized, and because of that, he has not been able to work. Therefore, if he has to pay a cash bond or a surety bond, he will be stuck in jail. So I would ask the court to take that into consideration, take into consideration also that he was so injured in this encounter that he had to go to the hospital, and that the alleged victim was actually arrested and charged with aggravated assault. Thank you, Your Honor.
All right, thank you. At this time, the defendant will receive a $2,500 surety bond. He is to have no further contact with the co-defendant, last name Jackson, and he must stay away from the incident location on Delow Drive. He can return one time with a member of law enforcement to get any items, and he is to have no alcohol, drugs, or weapons as a condition. Is there anything further from either party?
Nothing further from the state.
All right. Best of luck to you, sir. Who do we have next?
Position number 5, Mr. Goodwin. Good morning.
All right. Good afternoon, Mr. Goodwin. Your case is 22 CR 006311Y, in which you're charged with 1 count of battery, 1 count of disorderly conduct, and 1 count of public drunkenness, each with the offense date of September the 18th. Do you understand your rights?
Yes, ma'am.
All right. Thank you. Ms. Harvey?
3 cycles out of Georgia, 3 cycles out of the state of Michigan. The last arrest was November 13th, 2019 for terroristic threats and acts out of Fulton County. That case was dismissed, Your Honor. It appears the last conviction was from 97, which was out of Michigan for possession of weapons. Nothing further.
All right. Thank you. Mr. Dudley?
Yes, Your Honor. This incident took place on September 18th of 2022 at 340 Boulevard Northeast. The defendant and the preset bonds on this case, Your Honor, is going to be a total of $3,500 surety bond, and the breakdown that was set was $2,000 for the battery, $1,000 for disorderly conduct, and $500 for public drunkenness. The defendant was intoxicated and using profane and loud language. The defendant proceeded to attack the victim, Jamie Trepp. That's going to be spelling of Jamie, Trepp, Treep. He attacked Ms. Trepp by kicking her in the mouth, punching her, and then scratching her on her right arm and her back. Ms. Trepp had visible scratches on her forearm as a result of the attack. The state is going to recommend a total $4,500 surety bond, with the breakdown being $3,000 for the battery, $1,000 for disorderly conduct, and $500 for the public drunkenness. Stay away from the incident location, no further contact with the victim, and no alcohol, drugs, or weapons while out on bond. Nothing further from the state.
All right. What is 340 Boulevard? It's a home, a business?
Let me verify what that address
All right.
is for you.
I'm going to sound for the victim. Is Ms. Trepp on the line? All right, Ms. McLeod, please proceed. We'll come back to Mr. Dudley. We'll give him a moment to look for that.
Okay, thank you.
Your Honor, my client is 51 years old. He has been living in Atlanta for more than 30 years. He is the father of 2 adult children. One is 32 and 28, but both of them live outside of the state of Georgia. My client is not in a position to pay bond, Your Honor. He tells me that he makes a living by selling little nicks and knacks. He does not have a steady income. He has no one who can help him to make bond. He does deny attacking anyone. He tells me he has been the victim of considerable harassment from law enforcement because of his activities selling stuff to people, but he denies that he attacked anyone. He feels like that he was just arrested because he is a good and easy target for law enforcement because he's poor and he's somewhat disadvantaged. I can tell the court that he's definitely not in any position to pay for bond, Your Honor. So if he doesn't get a signature bond, he'll just sit in jail.
All right, thank you. And Mr. Dudley, did you confirm what that address was?
That was the Atlanta Medical Center.
All right, that was my concern. All right. So what we'll do at this time, the defendant is going to receive a $2,000 surety bond. It broken down as follows: 1,000 count one, 500 for the remaining charges. He is to stay away from the Atlanta Medical Center if he is not receiving medical treatment. Of course, if he is receiving medical treatment, he can return to that location. He is to have no contact with the alleged victim, Ms. Trepp, and have no alcohol, drugs, or weapons as a condition. Is there anything further from either party?
No, Your Honor.
All right, best of luck to you, sir. I believe that concludes courtroom 2. Is that correct?
That's it.
All right, you all take care. We'll go ahead and do the waived appearance.
May I be excused?
Yes, take care, Ms. McLeod. Have a great afternoon.
Thank you.
All right. We'll now take the case of Divine Smith, case 22 CR 006317D, in which defendant is charged with criminal trespass with the offense date of September the 17th. Counsel has waived the defendant's appearance. Ms. Harvey?
Yes, Judge. 4 cycles out of Georgia, 3 cycles out of the state of Nevada, a 2015 misdemeanor conviction for possession of drugs, a 2018 simple battery. The last arrest was February 3rd, 2017, which was a felony conviction for aggravated assault, hijacking a motor vehicle, armed robbery, and possession of a firearm during the commission of a felony. Defendant was sentenced 9/16 of this year, 2022, out of Fulton County to 5 confinement, 5 years indeterminate, and probation 5 years, Your Honor. Nothing further to add.
All right, thank you so much. Ms. Duncan?
Yes, Your Honor. In this case, it did occur on September 17th, 2022 at the Lindbergh Center MARTA station located at 2420 Piedmont Road in Atlanta. In this case, Your Honor, the defendant is accused of having jumped onto the tracks, possibly to receive a pin. However, patrons and users of the trains are not allowed on the tracks for obvious reasons. Given this, state does have some concern about risk of offense, given that he would just disregard the safety of himself and others at the train station to jump on the tracks for a pin. However, the state is amenable to there is a $1,000 surety bond on this case. The state is going to be requesting a $3,000 signature bond through pretrial. Stay away from the Lindbergh MARTA station. No alcohol, drugs, and weapons. Nothing further from the state.
All right, thank you. Ms. Kim?
No objection, Your Honor. Accepted.
All right. It'll be a $3,000 signature bond through pretrial per judge, because I'm sure that the defendant, I don't believe, was recommended. No alcohol, drugs, or weapons, and stay away from that Lindbergh MARTA station. Is there anything further?
No, nothing further.
All right, I believe that concludes the entire calendar. Ms. Bridgewater, will you review it for me, please?
Yes, I will.
Okay, once again, the reset date for the SAP calendar is going to be October the 4th. Position number 1 is a well, it's gonna be reset till tomorrow. Position number 2 is going to the SAP calendar with a $2,500 good bond. Position 3 reset to the SAP calendar with a $500 good bond. Position 4 reset further notice with a $5,500 SOB through pretrial. Position 5 going to the SAP calendar with a $2,000 total good bond. Position 6 is reset till tomorrow. Position 7 going to the SAP calendar with a $8,000 good bond. Position 8 reset to the SAP calendar with a $4,000 total good bond. Position 9 going to the SAP calendar with a $4,250 total good bond. Position 10 going to the SAP calendar with a $2,500 good bond. Position 11 going to the SAP calendar with a $2,500 total good bond. Position 12 reset further notice with a $6,000 SOB through pretrial. And position 13 is reset further notice with a $3,000 SOB through pretrial per judge. Are there any questions, comments, or otherwise? I think we're done. Okay. Sounds
All
good.
right, hearing none, we'll be in recess until tomorrow's SCA calendar, at which time I believe Judge Morrow will be presiding. Everyone take care. Have a great rest of your afternoon.
Thank
Bye-bye.
you, Judge.
Bye-bye.
Bye.
Have a good day, Your Honor.